So I'm going to start with a little bit of history before the Migratory Bird Treaty Act. Now, that's a hard thing to say, so I'm mostly just going to be saying MBTA, which is its abbreviation. So talk a little bit about what the conditions were before the MBTA was passed. Basically, why was it needed? Why was there a push for this law to protect birds? Talk a little bit about a few wildlife laws that came before the Migratory Bird Treaty Act, and then actually when the MBTA was passed, how did it pass? What does it say? And that's kind of the, what kind of protections does it offer birds? What kind of birds does it protect? What kind of rights and responsibilities does it give people? And then we'll talk a little bit about how the MBTA has historically been interpreted and enforced, and then getting into a little bit more recently, kind of how is that law applied today to help birds? Why is it still important? And then really getting into the more, the things that have been in the news more recently, these really recent interpretations, kind of conflicting interpretations from different administrations, and then some of the legal battles that resulted. And then finally, a little bit about the current state of the MBTA and kind of what still needs to be clarified and resolved in the future for this law to continue being useful. So before the MBTA, it was passed in 1918. So we're talking about the 19th century and the early 20th centuries. In that time in the US, there were really not many regulations on hunting in terms of when you could hunt or what you could hunt or how many you could hunt. There were some states that kind of tried to have their own laws, but they weren't very effective. So what ended up happening is you had what were called market hunters. So basically people who would hunt animals to take and sell at markets. So they would go out and they would kill dozens or hundreds of birds and other wildlife too, but focusing on birds here. And then they would take them back to the city and they would sell them to people to eat. And then in addition to market hunting, you also had a big market for feathers and birds to put on women's clothing. And this was actually an international problem that especially wealthy women, they wanted to have, the more exotic, the better, for birds to either feathers to put on hats or on bags or dresses. And as you can see in this picture, oftentimes entire birds would be used. And that was a really huge industry because it became a status symbol for both wealthy women in Europe and in the United States. And then there was also a lot of collection going on, both for scientific purposes. Scientific collecting was much bigger back then. And there were also a lot of people who wanted personal collections, especially wealthy people who had their own museums. And kind of the sad part about that is that as a bird got more rare, as a bird became more rare, the demand for it from a collection standpoint would go up, because you hear, oh, there aren't that many great auks left, or there aren't that many ivory-billed woodpeckers left, I want one. So you had a lot of pressure on these dwindling populations, and there are several species where that was a major factor in their extinction. So the combination of this overhunting, collecting for feathers and collecting for personal reasons led to several extinctions of North American birds in that time period. So mid to late 1800s into the early 1900s. So one example is the great auk, which officially went extinct in 1852. So these were basically big, dumb seabirds that would nest in really big colonies. They were good to eat. Their eggs were good to eat. So hunters would just go to these islands where there'd be thousands and thousands of these birds, and they would just slaughter them because they were easy to kill, because they were there, they weren't fast, they weren't very smart. And then the sort of final demise for them was because of collectors, that people heard that there were only a few of these birds left. So they went out, and there's actually like a firsthand account of the man who went out and killed the last known breeding pair because he had some wealthy client in Europe who wanted them. Labrador ducks, which went extinct in 1878, the story for them is a little less clear. Apparently they weren't very good to eat, so they weren't hunted that much. For them, it might have been more of a habitat issue, that they were really restricted to coastal habitat on the northern Atlantic coast of the United States and Canada. That's where a lot of people lived and where a lot of cities were. So for them, it might have been just more a factor of getting pushed out of their habitat by humans. Carolina parakeets, which I think their official extinction date isn't until like 1939, but they weren't really seen in the wild after the mid 1910s. A lot of the problem with them came because they would compete with farmers for agricultural crops. They would come in and destroy crops, so they would be shot because of that. And then also because they were so colorful, they were popular for fashion as well. And then of course, the biggest, most well-known extinction is the passenger pigeon. The last known bird died in captivity in 1914. So estimates were that when Europeans first started settling the United States, they numbered anywhere between 3 and 5 billion, which would make them one of the top few most populous bird species in the world. So you read accounts about these gigantic flocks that were a mile wide, and they would pass overhead for hours and hours and hours. So there's this idea that how can humans possibly make something that numerous become extinct? But a combination of dramatic overhunting and habitat destruction led to them being extinct in the wild by 1901, and then the last few captive birds were gone by 1914. So really a lot of these extinctions drove a lot of people to have more of this conservation ethic and to say, okay, we need to put something in place, we need to put some rules in place so that this doesn't keep happening. So before any laws got passed, we actually had early citizen conservation groups form before any wildlife laws were passed. So we'll focus on the Audubon Society. The very first state Audubon Society was formed in 1898. It was formed by two cousins who were active in the Boston social scene. So what they would do, they would hold afternoon teas with other wealthy women, other, socialites in the area, and basically talk to them and try to convince them to stop wearing feathered garments and feathered hats, and just kind of explain how this drive for feathers for fashion was having a really negative impact on bird species, especially egrets. You can see this political cartoon down at the bottom from the late 1800s showing that, even though it's other people out doing the hunting, it's really the women who are wearing the hats who are ultimately responsible for those bird deaths. And they were actually fairly successful. They got a lot of women to agree to boycott those. And by just 2 years later, there were 16 other states that had chapters of the Audubon Society, and they were all really focused on this feather trade and then also on overhunting. And these early groups were the ones that put a lot of pressure on state and federal governments to get stricter laws passed. The first Christmas bird count was held in 1900. It was proposed as an alternative to what were called Christmas side hunts. And a side hunt was basically you would go out with your family and you would kill as many things as you possibly could, as many birds as you could, as many small mammals as you could. And then at the end of the day, whoever had killed the most won. So in 1900, it was proposed, well, why don't we go out and count birds instead? So it's kind of showing this early conservation ethic starting up that maybe we shouldn't just be indiscriminately killing things. And then 1905, the National Audubon Society was founded and had a lot more political weight to kind of push for actual federal laws to be passed. So those were kind of grassroots efforts that led to some early wildlife laws. So the very first federal law that protected wildlife was passed in 1900. It was called the Lacey Act. This is Mr. Lacey. So what the Lacey Act did, it said that it was a federal crime to sell wildlife in one state that you poached from a different state. So like I said, there were some states that were starting to have different hunting laws, but let's say that it was legal to hunt mallards in Pennsylvania, but not in Maryland. So people would just go to Pennsylvania, they would kill a bunch of mallards, and then they would take them to Maryland and sell them. And because they'd crossed state lines, it was really hard to punish them or enforce any kind of law. So the Lacey Act basically said, if you carry poached wildlife across state lines, we can prosecute you for a federal crime, because the federal government is allowed to regulate interstate commerce, so they were legally allowed to do that. That law is still in effect today. It's not really used for the same purpose anymore because there's not much interstate commerce of poached wildlife anymore, but it's been updated over the years, and today it's actually mostly used to regulate forestry imports. It's been used in a few big settlements against big lumber companies like lumber liquidators who are basically illegally importing exotic wood. So still in effect, but not quite the same purpose as it used to have. And then the first attempt at a wildlife law to protect migratory birds was called the Weeks-McLean Migratory Bird Act. This was passed in 1913. It was this really broad law that said that the federal government owns all migratory birds, that every migratory bird in the country is under federal custody and it's under federal protection. And kind of using that authority that they had just given themselves, the federal government said that there's no spring hunting allowed, so basically no hunting during the breeding season, and most migratory birds couldn't be marketed at all. This was really, really quickly challenged and ruled unconstitutional because about 10 years before this, or maybe about 20 years before this, the Supreme Court had already ruled that states have the right to control hunting within their boundaries. And that's actually still the case today. So if you go to different states, in every state you have to buy a different hunting license. Different states have different hunting seasons, they have different bag limits, they control how things are hunted. So that idea is still in place today, that basically the citizens of a state own the animals within that state, and the state government sort of is entrusted to take care of them on behalf of their citizens. So the Supreme Court said, no, we already said that the states own the animals, so the federal government can't come in and change that. But conservation groups and the federal government pretty quickly figured out a way around that. So in 1916, the United States and Great Britain, acting on behalf of Canada, signed what is known as the Migratory Bird Treaty. So note that this is different from the Migratory Bird Treaty Act. This is just an actual treaty between two countries. And the idea was that a lot of these birds, they passed between the United States and Canada. So the two countries kind of had a mutual interest in preserving them and working together. So it agreed to stop all hunting of what they called insectivorous birds, which is basically what we would call songbirds. So songbird hunting is completely not allowed. And then for birds that are hunted, like waterfowl and different shorebirds, they agreed to establish hunting seasons. So people weren't allowed to hunt whenever they wanted to anymore. And kind of their stated goal was to preserve birds that were considered beneficial. So for example, birds that would eat insects in agricultural fields, and then birds that were harmless. So maybe they don't do us any good, but they also don't do us any harm. So this treaty was signed, and then, you know, a treaty isn't actually a law. In order to enact a treaty, you have to make a law that says we're going to do what this treaty says. So that's what the Migratory Bird Treaty Act was. 2 years later, Congress passed the mbta to basically implement this treaty, to say we signed this treaty and now we're going to make this law in order for us to uphold our half of the treaty. So the initial treaty was just with Canada, but over the next 100 or 50, 60 years or so, we also signed similar treaties with Mexico, Japan, and the Soviet Union, which basically just expanded the numbers of species that were protected. You know, there are a lot of birds that we share with Mexico, like green jays and other southern birds, that we don't necessarily share with Canada, and then not nearly as many with Japan and at the time, Soviet Union, now Russia. But it basically just expanded the number of species that were protected under the act. So what does the Migratory Bird Treaty Act say? We've been talking about it and I haven't actually told you what it does. So it's a really, you know, like any law, it's big and it's wordy, but this statement here is really the meat of it. So I know you can read, so I'll let you read it yourselves, but it basically says that unless you have permission, so either it's a bird that's hunted or you get some sort of special permit, you know, maybe you have birds destroying your crops or some other reasons, unless you have those exceptions, it is illegal at any time, in any way, by any means, to do any of these things to a bird. So basically to kill or to harm not only birds, but also their nests, their eggs, or any part of that bird, which includes feathers. So probably you've heard at some point in your life, or you've told people that it's illegal to pick up bird feathers and it's illegal to take bird feathers home. That's technically true. I'm not necessarily saying that the Fish and Wildlife Service is going to put you in jail if they find your feather collection, but basically the idea is if you have a bunch of feathers, they don't necessarily know that you picked that up off the ground. You might have killed a bird to take them. So kind of to do away with that ambiguity, you're just not allowed to have feathers. Now, if you start like trying to sell feathers on eBay or something, Fish and Wildlife might come and talk to you about that. But it's pretty broad and it's pretty straightforward. You know, at any time, by any means, you cannot do these things to migratory birds. And that kind of brings up the question, what is a migratory bird? You know, we know that not all birds migrate. You know, a lot of our woodpeckers don't migrate. The robins around here probably don't migrate. So does that mean that they're not protected? But in reality, almost all North American birds are protected under the MBTA. There are really two big exceptions. Non-native birds are not protected, and that was in the very original MBTA, that it had to be birds that were basically here naturally. So in our area, things like house sparrows, Eurasian collared doves, European starlings, they're not protected. So you could, you know, if you have a house sparrow nest, you can technically destroy it, and that wouldn't be against the law. I would prefer that you don't, but it wouldn't be illegal. And then for some reason that I haven't been able to quite find out, the whole group of what we call upland game birds were not covered. So things like ducks and geese, which are hunted, were covered by the MBTA, but things like quail, turkey, grouse, and ptarmigan are not covered. I've tried to find out why, and I can't. My best guess is that they've always been considered game birds. So they're still protected by hunting regulations. Like, you can't go out of season and kill a turkey. You can't go and destroy a turkey nest because they're covered by a different set of laws, but they're sort of excluded from the MBTA. So the MBTA was also almost immediately challenged on basically the same grounds as that Weeks-McLean Act, that they said it was an infringement on states' rights, that, you know, the Supreme Court already said that states got to control wildlife, so we can't have this law that gives the federal government power. But they'd sort of thought this out ahead of time, and this challenge ended up being rejected under the idea that federal treaties have the power to override state law. And this was actually a big landmark case for a lot of other reasons, because that decision basically applied to all treaties, that anytime the federal government signs a treaty and then signs a law to enact that treaty, it will override any state law that is contradictory to that treaty. So basically at the end, it gave the federal government this really broad power to protect birds from all sorts of things, from hunting, but also from, you know, poisoning birds or destroying eggs or anything like that. So it was a really powerful way to protect birds and aid with bird conservation in the United States. So getting into the enforcement side of it, where a lot of the kind of legal gray areas starts to come up. So first, the MBTA, it's enforced by the U.S. Fish and Wildlife Service. So they're the ones who are responsible for interpreting it. They're the ones who are responsible for going out and basically pressing charges and levying fines against people. So when we look at how this law is enforced, basically everyone has always agreed that intentionally killing a bird, you know, outside of hunting season, a bird that you have a license for, intentionally killing a bird is hands down absolutely illegal under the MBTA. It kind of fits the original impetus for the legislation, that when this legislation was first passed, there was a lot of concern about overhunting, and the MBTA, a lot of people see it as it was kind of directly in response to that. So there's never been any argument from anyone that this is one of the purposes of the MBTA. If you go out and if you shoot a curlew when you're not supposed to, you can get fined and potentially go to jail because you broke federal law. So for decades after it first passed, that was really the only way that the MBTA was used. It was mostly only used to prosecute poachers and to prosecute hunters who are hunting either out of season or hunting birds that they weren't supposed to hunt. But, you know, that kind of became less and less of a problem, and birds being killed indirectly by other causes started to be more of a problem. So beginning in about the 1970s, the Fish and Wildlife Service and federal prosecutors, they started to shift their attention to industries, and they started targeting industries whose activities ended up leading to bird deaths that they felt were avoidable. So the first case where this happened, it was actually against I believe it was a pesticide company that was manufacturing a lot of really toxic pesticides. And then all of that toxic wastewater, they were just storing outside in these open ponds. And birds like water. So birds would come and land on those ponds and they would end up dying from exposure to the toxic chemicals. So Fish and Wildlife and the federal government ended up fining them and saying, you know, you are causing the death of birds, and the MBTA says that you can't kill birds, you can't take birds. So even though it was indirect, even though they weren't going out and shooting birds, they said that the MBTA, it doesn't care if it's intentional. You killed a bunch of birds, so you have to fine, or you have to pay this fine. And one of the keys here, which is going to come up again, is that those deaths were potentially avoidable, that you don't have to put your toxic wastewater in an open pit. There are pretty easy ways to prevent that being a problem for birds. So today, most of the focus has pretty much largely shifted to industry. So the Fish and Wildlife Service tries to be proactive with industry. There's a lot of efforts, or there have been a lot of efforts over the years for Fish and Wildlife Service to work with industry to try to proactively reduce harm to birds, basically using the threat of the MBTA. So, you know, if you don't do this and you end up killing birds, then we're going to come fine you. So trying to get industry to be willing to work with them. So some examples of things that have basically become common practice because of this collaboration. So a lot of wind farms and solar farms, you have to do pre-construction bird surveys before you do them to make sure that you're not putting up giant windmills in a major migratory pathway. Oil waste pits and then waste pits from other industry having to be covered so that birds don't come and land in them. Insulating electrical lines and electrical substations to prevent birds from electrocuting themselves. So you can see in this picture here, basically in order for a bird to get electrocuted, it has to be touching two different pieces of electrified equipment. So if you put these insulators over some of the wires, then that bird can't be electrocuted because it can't reach far enough. So pretty simple, common sense things like that, trying to prevent these deaths before they happen, but using the power of the MBTA to kind of coerce or force industry to go along with it. Because they're not going to do it just out of the goodness of their heart. You have to basically threaten them with fines in order to make them do it. So this shift in focus, you know, it used to be a focus on individual people directly killing birds. And now recently, in the past few decades, the focus has shifted a lot to kind of forcing industry to be environmentally friendly. It's led to several different federal court rulings, which have mostly been contradictory, on whether the MBTA only prohibits purposeful killing of birds, like I go out with a gun and shoot a bird, or does it also prohibit what I'll talk about in a second, which is called incidental take. So a lot of the focus of these different lawsuits has been on this word take. So on the next slide, again, I'll show you this, the text of the law, but it says it's illegal to kill a bird, to hunt a bird, and also to take a bird. So what does take mean? Different people have slightly different definitions, but how the Fish and Wildlife Service has defined it is to pursue, hunt, shoot, wound, kill, trap, capture, collect a bird, or attempt to do any of those things. So there's actually a lot of redundancy with the other words in the statute. So take means to do any of these things. And then if we go back to the MBTA, so that word take fits in there, and, you know, all of these words that are kind of redundant. So this idea that take must have kind of a separate meaning from actively hunting something or possessing something or purchasing something. But you can see all these other words around take, they have a really obvious meaning. We know what it means to hunt something. We know what it means to kill something or to transport or to sell. This word pursue gave me a little bit of pause. I don't think it means like going to pursue a black hawk to look at it. I think there has to be some sort of harm involved, but fingers crossed. So most of the kind of legal issues and ambiguity has centered on this word take. So the conflict is that there's been two different kinds of take defined or that are talked about, you have intentional take or incidental take. So I'll give some examples on the next slide, but intentional take, it's basically you are performing an action and the entire purpose of that action is to take a migratory bird. So again, take in that broader definition. So your whole point of the action that you're doing is to cause harm to a bird, cause harm to its eggs, or cause harm to a nest. And just a side note that nests are only protected if they're active. So if they have eggs in them or if they have nestlings, if you have an old nest on your house with nothing in it, you're allowed to knock it down. And then kind of the other type of take is incidental take. So this is when take occurs as a result of some activity that's otherwise lawful, but it wasn't necessarily the purpose of that activity. So that one I think is easier explained with examples. So an example of intentional take, you have a Say's Phoebe nest on your porch light and you don't like it there because the bird is pooping on your porch. So you knock it down, and in the process of knocking it down, you destroy some eggs or you kill some nestlings. That's intentional take because the entire purpose of that action was to damage that bird's nest. Incidental take, let's say you have a tree in your backyard that you want to cut down and you cut it down. It turns out there's a pair of nesting owls in it and those owls end up dying because you cut the tree down. That's considered incidental take because the purpose of your action was to cut the tree down. And those birds were just sort of incidentally harmed as a process, as a part of that process. So the big legal question has been, does the mbta only prohibit intentional take or does it also prohibit incidental take? So for example, having a pit of an open pond full of toxic wastewater, the purpose of having that pond is not to kill birds, but incidental to that pond being there, you ended up killing birds. So you can see kind of the difference in those two types of take. So court cases, like I said, have centered on whether that incidental take is illegal. There have been really large convictions and really large fines against industry based on this idea of incidental take. So there were two really big settlements against wind energy companies or wind developers whose turbines killed a lot of golden eagles and then a lot of other birds. So there were two cases where companies had to pay millions of dollars in fines because of that. And then another good example is the Deepwater Horizon oil spill ended up killing tens of thousands of birds, and BP had to pay, I think it was something like $33 million in fines because each individual dead bird got a monetary value attached to it. So they had to basically pay for every bird that was killed because of that spill. And a lot of that money was used for research and for wetland and habitat restoration along the Gulf Coast. So there are cases where the Fish and Wildlife has used this idea of incidental take to basically punish companies for killing birds. And then industry stepped up, and in other cases they said, hey, this isn't fair. We're not trying to kill these birds. Our intention wasn't to kill these birds, so you can't hold us responsible. So there have been 4 or 5 cases that made it to different federal courts asking whether the mbta prohibits incidental take, and they've pretty much been evenly split, that 2 of the cases said yes, 2 of the cases said no, and then 1 was kind of a little bit more in the middle. So for those courts that said yes, incidental take is punishable, their argument was you just look at the text of the mbta. It says you can't take a bird at any time, by any means, or in any manner. There's nothing in there that says that you had to be intending to harm the bird. It just says if you hurt a bird, if you kill a bird, that is illegal. And then the courts that said no, incidental take is not prohibited, they kind of looked back, rather than looking at the language of the mbta, they looked at the original intent. And they said, you know, back in the early 1900s, the whole point of the mbta was to prevent hunting and it was to prevent poaching. So those are really direct forms of killing. And then they also said that, you know, Congress has had the opportunity to define this word take. They've had the opportunity to say, yes, incidental take is also prohibited, and they haven't done it. So we have to assume that they don't want to do it. So you have basically these really high courts that are split on their opinions. So it leads to a lot of ambiguity at lower levels about how you should enforce things. So to resolve these issues, we had two different opinions at a federal issue that were, or at a federal level that were issued. Oh, before I do that, that's why I put the slide, because I knew I'd forget. So on a side note, in legal terms, the word accidental is different from the word incidental. So sometimes you read news stories that say, oh, the MBTA means that if you hit a bird with your car, you're going to go to jail. But that kind of accidental take has routinely not been prosecuted. The Fish and Wildlife has the discretion to choose what they're going to prosecute and what they're not going to. So they kind of go a little bit further to define incidental as something that's reasonably anticipated or foreseen and potentially preventable. So for example, if you leave an open pit of toxic wastewater, you should reasonably foresee that a duck is going to come and land in that and hurt itself. If you have a barn that has a nesting barn owl in it and you knock that barn down, you should have reasonably foreseen that that barn owl is going to die as a result of that activity. Accidents or accidental take is something that's generally unforeseeable and unpreventable. So that would cover something like hitting a bird with your car. If you're out hiking or even walking through a parking lot and you step on a cryptic nest like this killdeer nest over here, that's something that's generally unforeseeable and unpreventable. Like, yeah, you could argue that, well, no one should walk anywhere, but that's a little bit unreasonable. So Fish and Wildlife has pretty much never tried to prosecute people for accidental take. So getting to the really recent stuff that kind of started the really recent legal battles that have been in the news. So the Fish and Wildlife Service is within the Department of the Interior, and the Department of the Interior has what's called a Solicitor General, which is basically the top lawyer in that department. So basically, whatever that lawyer says about the laws that are enforced by that department, that pretty much goes, because they're the legal authority. So if they say that a law should be enforced one way, that's how it's going to be enforced. So there are two subsequent administrations where the Solicitor General of the Department of the Interior issued an opinion on the Migratory Bird Treaty Act. The first was in the Obama administration, Hillary Tompkins. It's just informally called the Tompkins Memo. So if you look at this date, January 10th, 2017, that's when there was about 11 days left in the Obama administration. So it was just this kind of last ditch effort, this Hail Mary to say, okay, we're gonna write down what we think about the MBTA and hopefully it'll carry into the next administration. So she looked at the history of the MBTA, including its original intent, its original language, the different amendments that have been added over the years. She looked at the case law and people who had tried to either people who tried to take the MBTA to court or people who were taken to court by Fish and Wildlife. And she looked at the standard practices of Fish and Wildlife over the past 100 years. And she determined that from all these things, she determined that the MBTA does prohibit incidental take. And a lot of her opinion was basically based on what the Fish and Wildlife Service has done for the past decades, that they have always acted like incidental take is not allowed. So that's how we should continue interpreting this. And then about 3 or 4 weeks later in the new administration, her memo was basically, I forget the exact word they used, basically withdrawn and put on hold until the new administration could review it. And then on December 22nd, 2017, so less than a year later, the new Solicitor General, Daniel Giorgiani, completely rescinded the Tompkins memo and came out with complete opposite conclusion. That he said the MBTA does not prohibit incidental take. The reasons that he gave was that it never mentions the word incidental take. He tried to interpret it because the word take is next to the word hunt and kill. Those are all intentional things. So take is only legal if it's also intentional. And he said that even if, that basically only direct actions that are taken against birds are prohibited. It doesn't matter if you are trying to hurt a bird or not. Basically only something that's done directly to a bird is illegal. So cutting a tree down that a bird is nesting in, that's not illegal because you weren't doing it to the bird. So came out complete opposite conclusion. And he actually admitted in his memo, he said, I know that this is not how the Fish and Wildlife has interpreted this law in the past, but this is how I think we should interpret it now. A lot of people saw this as an effort to reduce regulations on industry because, like we talked about earlier, in the past several decades, most of the regulatory focus of the MBTA has been on trying to get industry to be proactively bird friendly. Sort of probably not incidentally. Before he was a Solicitor General, Daniel Giorgiani worked for Koch brothers, which have a lot of stake in petroleum industries. So a lot of outsiders and outside conservation groups really just saw this as an industry insider trying to pass a law that reduces regulation on industry and kind of allows them to indiscriminately cause deaths of birds. So this opinion, it led to the Fish and Wildlife Service kind of putting out this official memo about how the MBTA was now going to be interpreted. And some of the examples that they gave were pretty telling. So one of the examples that they gave, they said, let's say that you have a chimney in your house and there are chimney swifts nesting there, and you know that there are chimney swifts nesting there. If you light a fire with the purpose of killing those chimney swifts, that is illegal. We will punish you for that. But if you know that those birds are there, you know that they're nesting, and you light a fire with the intent of heating your house and you end up killing all those birds, that's fine. Because your intention was not to kill those birds. Your intention was just to warm up your house. So it doesn't matter if you knew that the birds were there. It doesn't matter if you knew that what you did was going to kill those birds. Because technically you were just trying to warm your house up, then that's not illegal. They also gave the barn example that if you have an old barn and you know that there are birds nesting in there and you knock the barn down just because you don't like it and you end up killing all the birds, that's fine. Because the purpose of your action was to knock down a barn. The purpose of your action was not to kill birds, so we're not going to hold you liable for that. And it really took away all of the ability of the Fish and Wildlife to work with industry, because now the industries knew that they would never get punished. If they threw up a windmill right next to a golden eagle nest and that eagle ended up dying, they're not going to get in trouble for that because the purpose of that windmill was just to make power. So this memo, this opinion was challenged pretty quickly. The National Audubon Society led a coalition of several other conservation groups. They filed suit against it about 6 months later in May 2018. So they said the legal term was that the memo was arbitrary and capricious, and that kind of the meat of their argument was that it reverses this really long-standing traditional interpretation and implementation of the MBTA. So it was Audubon, American Bird Conservancy, Center for Biological Diversity, and Defenders of Wildlife. And then 2 other really similar suits were filed. One was filed by a group of 8 states, and then one was filed by 2 other conservation groups. And they basically had really similar arguments, that the position in this memo is just contrary to how the MBTA has been enforced, and it's contrary to the very plain language in the MBTA that says you can't kill a bird by any means, any manner, any time. So the ruling on those challenges, all 3 of those suits were basically grouped into one because they were so similar. The ruling just came out on August 11th, so very new, probably what you may have seen recently. So the resolution was basically all the groups suing the Department of the Interior won. So good news for birds. That the district court judge in, I think it was the Southern District of New York, she ruled in favor of Audubon and all the other plaintiffs. And I actually read through the entire opinion yesterday. And it's pretty strong language throughout that she's very clear that this memo, it doesn't align with the history, it doesn't align with the intent, it doesn't align with the very plain language of the MBTA. So she said, the Giorgiani opinion is contrary to the plain meaning of the MBTA and therefore must be vacated. So that basically means that this memo has no power anymore because I don't think it's legal. So this was kind of the quote from the very end, right before she gave her ruling, that there's nothing in the text of the MBTA that suggests that in order to fall within its prohibition, activity must be directed specifically at birds. And it doesn't say that only intentional killing is prohibited, and it doesn't say that only some kills are prohibited. It just says killing birds is not allowed. It doesn't matter if you meant to do it or not to do it. Killing a bird is illegal under the MBTA. So this was a really big victory from the perspective of conservation groups and from bird conservation, especially in a year where we've gotten all these articles about, 3 billion birds and 30% decline in our bird population. This was kind of a really heartening thing to happen. So currently, the Department of the Interior is still going through this rulemaking process to try to make it an official rule that incidental take is not illegal, but that will probably also be immediately challenged. And it's a lot more likely that that challenge will succeed because now we have this really recent case law to say, well, if the memo that drove this new law or this new rule is wrong, then this new rule is wrong also. This new rule is wrong also. I don't know what I just said. So really kind of at the broad scale, this is just one more court ruling that adds to that conflicting case law, but it's a little bit more powerful because rather than just ruling on, one person who's trying to say that they shouldn't be sued, it's ruling on this big legal opinion of the Solicitor General of the Department of the Interior. So it will probably carry more weight going forward. But really, these lawsuits are going to keep happening until either Congress or the Department of the Interior really formally clarifies what the intent of the MBTA is. So, 2 solicitors generals tried to do that, and one got canceled out, the other got told that it was illegal. So maybe the next Solicitor General will try again, or Congress can step in and actually modify the law to very clearly say one way or the other whether incidental take is allowed or not allowed. So we've definitely had a big victory in the past month, but things are still not settled. So hopefully in the near future, that'll all get cleared up. And with that, if there are any questions, I'm going to stop sharing my screen. So that way, if people have questions, we can unmute them and we can